should the association ban the following from the pool area? And I'm going to read them before I launch the poll. F the board t-shirt. That's what the guy wants. That's what somebody wants to wear. That does happen, I will tell you.
Does it have the 2 dots, or is it actually the word?
Well, you know, you lawyers. All right, here we go. Here we go. You know what? In your commentary, let me know if it makes a difference. Okay.
Okay.
All right. Because I didn't even think of that, to be honest with you. So F the board t-shirt, a Nazi t-shirt, which is a don't hate group. I hate the USA t-shirt, which many people would find offensive. An anti-Russia t-shirt. Hey, maybe you hate Russia. You want to make a political statement. Or a topless photo t-shirt. You know, a photo of somebody topless. Guess we would obviously say female or something in that kind of realm. So let me launch the poll here and see where our audience comes in. And I really don't know where we're going to be with this one and where everybody's going to come in. Dave, as the audience is voting, let's jump ahead a little bit. Do you see a difference between the way I wrote it and if it's spelled out altogether? Is that going to matter?
I don't know that it would matter legally. My first assessment would be that if the board's going to attempt to ban certain attire that people bring, it has to be prepared to go all the way with it, because I gather that if a person's wearing a, I don't know, F the board t-shirt, the guy's not going to take it off when you go over to him and tell him to take it off, right? So you're going to have to be prepared to go all the way and enforce the rule.
Don't get ahead of me. I just wanted to know if you thought there was a difference between F blank blank K or somebody writing out the word. But let me go to the poll.
If the board's going to try to enforce it, yeah, I think there would be a difference, yeah.
Okay. So let me share the results where the audience came in. So they said that the association 54% said sure they could ban that F the board t-shirt. 71% say they could ban a Nazi t-shirt. 38% said both hate USA and also anti-Russia t-shirt. And wow, so pretty high numbers as far as the audience saying, yeah, sure, the association could ban these items. Okay, so attorneys, I want to leave a little bit of room for you guys, for each other, but I'll start off with Dave. What do you think about the poll? And take a piece of it, Dave, and what about the legalities of it?
I think the poll reflects, I think, the natural sort of instinct of regular people, you know, which would be a t-shirt with a swastika on it would be, oh my God, we have to ban that. But a t-shirt with I hate the United States on it, which arguably we see around us every day, not so offensive. These types of things, the board is probably able to regulate from a legal perspective, because I don't believe it touches upon any of the discriminatory types of things. But the Nazi T and the Russia T does potentially create some sort of hostile environment, which the current federal government administration interprets as potential fair housing violations that a HOA or a condo has to actively or affirmatively try to prevent. So maybe in that regard, between those five, a board may have an affirmative obligation to attempt to regulate that. So that would be, on the one hand, meaning an affirmative obligation to deal with it. On the other hand, whether the board has the right to deal with those things. And I'm probably, from a legal perspective, not necessarily a practical perspective, but I think legally there probably could be a rule that limited the type of clothing and the type of things that are worn in common areas where people congregate. That probably would be sustained based on the example that I'm seeing here.
All right, so I think this is going to vary from attorney to attorney, possibly, because I've asked these kind of questions in different pieces throughout the years and gotten different responses. So, Sean, I'm hearing kind of a gray area from Dave a little bit. If I'm wrong, Dave, just interrupt me in some cases here, which is exactly what boards don't like. Commentary, Sean?
Yeah, I mean, a couple things. One is, to the extent that the association is going to make the decision to proactively regulate and attempt to police things that are written on apparel, it would be imperative to have a very specific set of rules so that it's not being dealt with on a case-by-case basis, and it's very, you want to eliminate any ambiguities and make it clear and black and white as possible so that it's consistent and it's fair and it's sensible. And of course, this is something that would be worked through with general counsel. I mean, I think you're going to run into some policing issues with all those things. I mean, I put number 1 and number 5 in the same category, that it sort of offends the sensibilities of something if the word is spelled out. Like if it's not spelled out, I think that does make a difference, because you could spell other words like fork that fit in that same. So, I mean, everybody knows what's trying to be implied, but you can imply things and that's not offensive. But if it actually says the word, and if you have the topless photo, I think those would be things that could be reasonably regulated and prohibited. The Hate USA, I think you just have to live with that. And I think I agree with David that the number 2 and number 4, it could trigger that FHA obligation that came around with that amendment from 2016, where one homeowner is harassing another homeowner. It triggers obligations for the association to step in and use its authority to prohibit and prevent that harassment. So those are considerations to think about.
All right, John, let me read some of the comments before I go to you. First of all, the manager that sent me this, so ingenious. Hey, they could be saying it could be funk the board t-shirt. So that's an interesting aspect of that. But, we're making we're assuming that it means something else. And that's actually great commentary there. Sure, they could. Dave, does that change your opinion of that a little bit?
No, I think he's definitely right. I think it's consistent with sort of I was saying. I think the removal of the U and the C in your example, I think does change the dynamic. And in fact, that's the intent of the, I would say, author, meaning the speaker, the person. Their intent is to make a point without being nasty about it, without being, rude is probably a better word. I mean, obviously everyone knows what it means, but it's an attempt to thread the needle between rude and between I have a right to say what I want to say.
That's why I love the comments from the audience. Here's some more commentary. I would think that free speech would allow any of these shirts unless the board has proposed rules that do not allow certain things that would be on a t-shirt. I think curse words would be a rule that could be enforced, but if they wanted to not allow the other shirts, it would be more difficult to list all those different shirts. I'm reading these as I go along here, audience, the best I can. And don't worry, audience, I am going to, get the lawyers to give us a little bit more well-defined answers if they could. Now everyone's sending me different interpretations of what F blank blank K could be. I appreciate that, audience. I got it. Thank you so much. John, another comment that came in, we actually did a short video on this. This is what people think as far as owners go. Not if it doesn't name the board or anyone on it. This is about the board t-shirt. It makes an insinuation that multiple conclusions could be drawn from. It doesn't target any specific person or entity. And an HOA certainly can't tell you what clothes to wear. All right, so John, I threw a few different things at you, commentary from the audience. Why don't you take it from there?
You threw a lot at me there. I actually agree with pretty much everything we just heard from Dave and Sean. And then the comment that someone made about most of these things you should be able to do if you don't have a specific rule tailored to it. But following on the affirmative obligation of boards to deal with Fair Housing Acts, if someone wearing a Nazi tee, for example, or the topless photo, if you know it's going to be repeated, you might want to get out there and create a rule. So maybe there's no Fair Housing Act issues with topless photos, but you could have pool rules, that are tailored to not having t-shirts with topless photos, and I think that's enforceable. Free speech rights, and this is the important point, don't necessarily apply in private associations. There is a little bit of a balancing act, and I think as far as like foul language, as long as you're not threatening to hurt someone.
Stick with the t-shirt though. We're going to get into the speech. Don't get ahead of me, but go ahead. Thanks.
I don't think there's a crime involved, so I don't think you have to worry about that. But the two ones I think the board is probably has the ability to enforce with specific rules would be the first one, the second one, the third one. The anti-Russia T, probably not much you can do about it unless you're in a community with a lot of Russian Americans, for example. That might be, like just almost every association has rules against offensive conduct, so that possibly could work too. But again, I agree with the comment that you need specific rules to deal with these.
All right, so the audience really, I've been asked by multiple people, they really want me to narrow this down. So John, really quick, which ones do you have a problem with? Which numbers?
2 and 5.
Dave, how about you? Which numbers do you have a problem with?
I'll give you my numbers, but I'd first like to just sort of say with a client or a listener's frustration is understandable. Part of the situation. The frustration is not the result of lawyers being unclear. It's the result of the fact that the dynamic is unclear and it requires nuanced conversations, not one word answers. So I know it's frustrating for people. This is how I feel. Maybe John and Sean feel differently, but I don't feel that there's a reluctance because lawyers are unable to communicate clearly and succinctly. I think when you're dealing with these types of issues, there are things that require a nuanced perspective, and boards are going to have to not be so frustrated with the fact that there is not I don't want to belabor the point, but I think this is helpful. I tell clients sometimes, look, if I'm a school board lawyer and someone comes to me and says, I want to have a water fountain for African-American students, I want to have a water fountain for white students, I can say absolutely for sure that is illegal. But you don't often get questions that are so easily answered, especially in the context of what shirts you can wear at a pool, and then when it's broken down even 5 ways. So I'll say, getting to the back of the answer.
Wait, Dave, let me rephrase, because you're right. It's unfair to you guys. You always have an area to say where it's a gray area. It's not really fair for me to put you on the spot with yes or no. So that's
okay.
That being said, Dave, go ahead on which numbers.
Yeah.
Just go through them and what you feel are a problem.
I think the board probably has the right to regulate all of them as long as it's done in a reasonable way, consistent with the fiduciary duty, and there's no, undercurrent bad faith involved with how it's going down. But the board could probably regulate all of them as long as it was handled in the correct above board way and with rules like John and Sean have suggested, that kind of thing.
Sean, like the audience would just like a little bit more well-defined, but by all means, please use that gray area card if you need to.
Yeah, so it's one thing you said, Ray, is you said, like, don't get ahead of us because we're going to talk about speech. The thing to emphasize is this is speech. Words on a t-shirt are speech. That's why we're talking about this. And what's very important to understand is that it's a private community, it's a private organization, and the First Amendment simply does not apply. It just doesn't. You're not going to, no homeowner is going to win that and say, oh, I have a right to have free speech here. It's not. It's a private community. It's a private organization. It's allowed to make rules and enforce them. The question becomes, like, does it really make sense? And which hill are you picking to die on? I'll kind of go back to the categories that I have. I think 1 and 5 can be sensibly regulated if the word is spelled out in number 1. If it's not spelled out, I don't think you want to mess with it. I don't think it makes sense. But if the word's spelled out, then 1 and 5 are the same. You could make a reasonable argument that they just offend community standards, and we don't want cuss words and pictures of nude people on shirts. That makes sense. Number 2 and number 4, I mean, I think you're really into discrimination, and that would be a reasonable basis to regulate those. And number 3, nobody wants to see that. We don't like that, except I guess the people that do actually, hate our government. But that's just something where I just think you don't want to die on that hill. You just, if somebody has a shirt that says I hate the USA, that's just not a fight that it makes sense for the HOA to get involved with.
Thanks. I appreciate you guys diving in on these. And like I said, audience, remember, first of all, we're not giving legal advice today or professional advice. We're just talking about general concepts, and none of these attorneys have all the background they would have in a real case to make these kind of decisions. So, and the audience is thanking you guys for diving deeper into that. All right, a couple other really interesting comments. Would signs be the same, Sean, as t-shirts? Can we count signs working the same way with the advice?
Yeah, I mean, to the extent that of this discussion about content and what's on the sign, then yeah, I think the analysis, this discussion would be directly applicable. But you know, signs have different aspects and different particulars when you're talking about regulating them, because then you're not talking about what you're doing in the common areas. You're talking about you know, regulating use of one's property and how it looks from the curb, and you know, and all that kind of thing. So it has a lot of different angles to it and different considerations than t-shirts.
Right. So Dave and John, I don't want to get into signs in that aspect. Yeah, there's all kinds of rules about where they can be, the size they could be. We've done entire sessions. Dave, any additional commentary as if you follow all the rules for signs and they're allowed and you put this stuff on there? Go ahead.
Well, I'll say it's important. Sean was definitely correct about his constitutional point before. The United States Constitution clearly does, not apply it. A college fraternity can decide what you can wear at a chapter meeting just as much as a HOA can decide what you can wear at a pool in relation to the United States Constitution. Now, on a state-by-state basis, some courts have been more, I don't know what the right word is, expansive maybe on their own constitutions. And we have that in New Jersey, and it can get even lower than that. I mean, you could have local laws in certain jurisdictions that limit the rights of a private organization to stifle expression. And I think you have to work if you're a board, you have to work the tree, you have to work the analysis all the way from top to bottom, and realize and decide whether or not on a local level the constitution of your state or a local law would apply. And it might.
Yeah, I mean, Dave makes a really good point, because while I don't practice in Jersey, I know they have, for example, laws with regard to political expression around election time, but New York doesn't have that. So again, you don't have the constitutional rights, the federal constitutional rights that everyone assumes you have, don't necessarily exist in the HOA. But on the flip side, you ought to have very specific rules to deal with these situations that come up.
I don't want to dive too much deeper on this part of the segment, but John, someone is asking, what about if somebody had a tattoo? Which is very interesting, because obviously, well, I guess you could tell them to cover it, right? What do you think of that when I mentioned a tattoo, John? Does it make any difference?
Well, I mean, you just gave the answer. They could cover it. It's not like, even if they have a right to it, it's the expression of the right that's the issue. The ability to cover it, it's kind of like I think you could treat it like a sign.
Okay. Any additional commentary, Dave or Sean, in regard to a tattoo being any different compared to just covering it?
Sean can certainly chime in too, but the tattoo thing is just, again, brings to light the bottom line question has to be is, and Sean I think has intimated this a couple times, what level of how detailed in the lives of regular people is a HOA board going to get? I mean, is a management company going to be expected to follow some guy around and see whether he's covering the tattoo for no? I mean, it gets to a point where once as a governing body, once you begin to go there, you have to go there, and then you will ultimately get complaints about how you went after one guy's tattoo and not the other guy's tattoo. You open yourself up to the idea that once you allow yourself to, as a board, get in the world where everybody's whining about somebody else's thing, and they can't just walk by a guy on the street who's saying really bad things and how awful it is to hear him, and you just keep on walking. And 5 minutes later, you forget all about it. Now, if the guy hits you in the head, you stand up and it's violence, you take care of it. Boards have to decide like how much they really want to get into the nuance aspects of how individual people just express themselves. It's very, very dangerous and very, very difficult.